Hey, good morning, Mike. Happy Wednesday, everybody. What's new in North Carolina?
Hump day. You know, not a lot. Still beautiful out.
Here.
Roses are starting to bud. I always like that.
Yeah, we've got flowers everywhere here. Happy Whack-A-Mole Wednesday, where you know it's coming, but not exactly from where. That's what Maury says. Whack-A-Mole Wednesday. I like that. So anyhow, here we are.
Got plenty of people here. And hey, Maury. Hey, Luttrell. Hey, Julian. Hey, Uncle Pat.
Who's Carrie Berry's mom?
Carrie Berry's mom.
Who do that be? Who do Carrie Berry be? You know,
Deanna Scholler. Good morning from Alabama. Good morning.
So look, let's talk about some breaking news. Title IX. I mean, huge. What the hell happened there? You know.
Yeah, this is a couple of days ago, so we're starting hot. couple of days ago, and I think on our at the end of our Monday stream, we kind of forecasted that we would be discussing the Biden administration's rollback of Title IX with respect to campus due process protections in sexual assault cases or sexual assault allegations, and our normal audience is aware of Norm's work in the case against Yale. And for that reason, I'm going to simply hand the baton to Norm to talk about what Title IX was and then what it means for the standard to be changed to something a la a preponderance of the evidence and an incomplete showing of allegations against a complaint against party.
So Title IX is a federal statute that guarantees equal educational opportunities on the basis of gender to people involved in, and I use that term in a broad sense, federally funded educational institutions, both students and faculty. And so I've had a couple Title IX cases with Yale that have made the news, one involving a student named Saifullah Khan, who was accused of campus rape back in 2015. He won an acquittal and then faced a university-wide Committee on Sexual Misconduct hearing at Yale. That hearing concluded that he had in fact engaged in sexual misconduct, non-consensual sex, and that as a result, he was expelled. And he was expelled as a result of a hearing that we found to be fundamentally flawed. In that hearing, we left. Sorry about that. I'm distracted today. In that hearing, we found how to characterize it. He went to the hearing. He couldn't cross-examine the witness. He could not. He couldn't cross-examine the witness. He couldn't appear in the room at the same time as the witness. He was unable to engage in all sorts of procedural activities. And the result of that was that he was expelled. We claimed in violation of due process. We brought a federal action. And in that federal action,
Are you limited in how you can talk about this, Norm?
No, I'm just preoccupied with other things today. In that federal action, he
let's back up. Let's talk about due process generally, and in the context of rights of the accused on college campuses. This Title IX change is branded as a rollback of Trump era changes to allow for the accused to do simple things like confront their accuser. And on the bottom of the screen here, Norm, I put "Me Too ain't dead yet." This feels a lot to me like sort of a reigniting of the era that we have seemingly just gone through and seem to be pretty well through. with respect to allegations of previous sexual assault, etc. And in the case that you just referenced, and you've talked about it ad nauseum in previous instances, and it's been what, a 9-year long endeavor with that client. How long have you had that client?
Yeah,
Almost a
we got him in
decade now?
2015. We tried the criminal case in 18. We went to federal court in 19. We challenged the due process clause, the due process implications of Title IX. A Title IX due process claim does not arise from a constant. I'm not well today, guys. I've been suffering, and I think I'm just going to have to abruptly end this today, and we'll talk tomorrow. All right,
It's
Mike.
okay.
Thanks. I'm going to hit. I think I'm just preoccupied, and I need to.
No problem.
I need
No
to take a
problem at
break.
all.
Right. All right. Thanks. Bye. All right.
See you later. So we will be back tomorrow. Take that off the screen. We took the day off yesterday. He's recovering from a flu, and I was skeptical that he may need another day or so, but he is a warrior. I'm not going to spoil the surprise. I do want to give both of these issues, both the non-compete and the Title IX issues, their moment in the sun. These are two issues that Norm and I respectively care a lot about. Obviously, Norm has given a decent portion of his legal career to the issue of Title IX and due process, so I'm not going to try and steal any thunder there. And then many of you know, but some of you don't know, that I'm a practicing lawyer, but I'm in the business and transactional world primarily. I rarely litigate, and if I do, it's normally against more of an administrative court in front of administrative law judges, that sort of thing. And the occasional, sort of local counsel for trademark cases, First Amendment cases, that kind of thing. But in the world of business, my clients tend to be regional sized businesses, those that can the FTC regulate contract law? Well, they just did. And the U.S. Chamber of Commerce will decide more. But I look, I'm not going to spoil that stuff. Nor Julian said, Mike, tell us about your practice. I will, and then I'll end this stream here in just a couple of minutes. But I'll at least introduce you all. Some of you are new. I graduated from law school in 2015. And I started a practice directly out of law school after I passed the bar that summer, called Carolina Craft Legal. And it was my mission to develop a practice that would be transactional and business focused, sort of a, how do I say this? Sort of a one-stop shop for what was a growing segment of the beverage alcohol sector known as craft beer. And, during my time in law school, I had experiences that gave me a really fundamental understanding of the business of beverage alcohol, from the manufacturing to the wholesale distribution, retail, and the full value chain. And within that, or laying atop that, the federal, state, and local legal overlays and how to navigate that kind of stuff. And then corollary issues related to employment and HR, contracts, vendor agreements, trademark law, all sorts of stuff that spiders off of nearly every business. And so, Carolina Craft Legal was intentionally narrow, young attorney with no life experience, no practice experience. So my biggest concern was, developing a practice that began to, I guess, be that was servicing a singular sector, but also incurring, consultation requests for businesses and in subject matters that we weren't prepared for. So over time, that practice that was sort of front end business, transactional, administrative, regulatory based, has grown pretty substantially. We occupy more of a sort of a muscle boutique role now with our stable of clients, and we handle anything business and corporate. And when it comes to matters of contract, when it comes to matters of business strategy, vision, tactics, and then relationships with key employees, things like non-competes, grown-ups understand that they occupy a very valuable role. But what is clear to me based on the feedback that is circulating online, um, is that many people don't realize that non-competes are contracts, right? Offer acceptance consideration. And Ellen asks, "Were you destined to be self-employed?" Yeah, I didn't go to law school with a dream of being, Perry Mason. I went to law school on a pretty substantial scholarship because I needed more time to figure out what I was going to do with my life. It just so happens that law school was um, a revelatory moment for me, and the light bulb went on, so to speak. Um, yeah, been there, done that. Are you a corporate kind of lawyer? Yeah, I would say so if you had to kind of box it in. But in my practice, because alcohol is one of the most heavily regulated industries in the United States at the federal and state levels, a lot of what I do bleeds into where norm practices on the criminal side, because there's an easy transition from sort of the civil and administrative area that regulates alcohol, and then criminal conduct. And so, Norm is sort of a de facto mentor as I continue to get pulled in more and more into some of the sort of criminal feeling um, legal issues. But with respect to non-competes, like I said, I'm not going to spoil the surprise or steal any thunder from Norm. I definitely want him here as a sounding board. Yeah, been there, done that. Have you seen Utah's alcohol laws? I have. I have. They are abysmal. Um, a lot makes sense when you look at their alcohol laws. Here in Australia, non-competes are at least problematic and at worst impossible to enforce. Yeah, so I've written about this before and then taken stuff down. But the main issue it breaks down in two ways, right? There's the issue of legal enforceability, so time, territory, and scope, and the question of adequate consideration. That's legal enforceability. And then there's discretionary enforceability, meaning that an employee has the ability to negotiate for his or her own labor. And that's an important feature of this. What we're talking about broadly is that the FTC has made a rule that abrogates every individual's right and to negotiate for their own labor to a certain degree, right? And it also undermines state law in every single state. So what the FTC did yesterday, just in broad strokes, is effectively tell every individual in the United States that you are incapable of negotiating on your own. You can't be trusted, blah, blah, blah. And then to all the states, doesn't matter what your law is, we are going to preempt whatever you have on the books by way of statute or otherwise, and regulate this part of the industry and force businesses to do what they were trying to do with non-competes through other means, such as non-disclosure agreements and confidentiality agreements. There's a bunch of BS in there about, better pay, better working conditions. But anyway, mean Mr. Booze, he's whipped a lot of good men. Yeah, he has indeed. And that's an interesting, Steve, that's a great, with respect to craft beer, I almost need a different podcast on that stuff altogether at this point in my legal career. But I will say to that craft beer enjoys a certain lack of scrutiny that other beverage alcohol products have historically not been able to avoid. And I think that is a meaningful observation to make, especially here in North Carolina, where the state government is running pretty wild with shutting down retail establishments and whatnot. If non-compete is optional to employment and gives a person $10K a year, I do not see how it would be illegal. Yeah, I think that the issue is necessarily that most people aren't aware that there's a non-compete at the front end of their employment, or even if they see it, they're unwilling to consult an attorney, or they feel as though they don't have the leverage to negotiate away from that non-compete. And in the case where there may be risk of, the non-compete of violating the non-compete post-employment, they're unwilling to consult an attorney at that point to determine what the potential risks are, to make an objective appraisal of how litigious the employer might be, or whether it's, whether the non-compete that they're subject to is likely enforceable based on existing precedent in that state. Um, that's Rose. Yeah, nice dog. That's my boxer, Rose. Can craft also include spirits, e.g., craft vodka? Of course. Um, Craft is sort of a stand-in for small, and I don't want to say handmade, but craft is just small. A Mike podcast would be welcome. Well, thank you. Does this cover non-solicitation as well? I assume no. Yeah, covenants not to compete and covenants not to solicit usually are companion provisions, and I'll talk more about this in detail. But the covenant not to solicit, it would be more of a it, yes and no, and I'll talk more about that tomorrow. People shouldn't need to consult a lawyer when changing jobs, though. Right. So read your employment contract before you take the job. I just don't have look. I just don't have look. You're not going to catch me, defending McDonald's if if they have systemically added non-competes to their service category, right? To their just hourly wage part-time workers, stuff like that. You're not going to catch me defending the enforceability from a legal perspective of those non-competes. I don't think that those are that important, right? And I think that that's probably done in bad faith. But I also think that there are ways that government can regulate that doesn't require an outright abridgment of one's ability to negotiate for their labor or constraints on their labor. We have a lot of craft beer and liquor in West Michigan. Yeah, Michigan, they were Michigan during, my formative craft beer years, I would say, was famous for Bell's Oberon. And, before that was widely and available year round, that was sort of a seasonal thing. McDonald's should start doing non-competes with how wages are in California. Fair point. Fair point. Let's see. It says expensive to fight regardless of the merit or lack thereof. Yeah, I mean, it also depends on one's risk tolerance. And again, consultations typically aren't that expensive. I think that, people are nervous to engage lawyers. Maybe at some point my time will be sensitive enough that I'll need to charge for consultations. But even, I'm in my 9th year of practice and I don't charge for consultations. And there are many attorneys that even if they do, will return your consultation fee or your retainer if they decide that they don't want the case or that you don't have a case or whatever. My wife has a very strict non-compete on me. Yeah, likewise. There are a lot here in the Metro Detroit area too. Yeah, craft beer is interesting, and if there's a demand for some, if people want to talk more about craft beer at any point, I've got opinions and I've got experience. One of the most interesting things to me about beer, the business of beer, is distribution, because every state has its own version of the 3-tier system, which necessarily creates an independent wholesale distribution tier between manufacturers and retailers, to avoid monopolization of markets by big suppliers, a la Budweiser, et cetera, right? So you literally have, by creatures of state statute, you have legislated monopolies in favor of distributors, basically entitlements to profit, where these businesses exist purely to avoid manipulation of the market in alcohol. Fascinating stuff. I get some great moonshine from the VA mountains. I don't know anything about that. Craft beer is off the hook in Northern California. Yeah, craft beer kind of is having a waning moment right now, though. If you start to pay attention, I think that, what an industry that was kind of marked by consumer promiscuity, and a, just sort of a boundless aspect of new has kind of worn off. Many have struggled through the COVID era, and the first-time business owners have largely been exposed for lack of experience, lack of intelligent decision making, and inability to evolve in a way that accommodates shifting demands of the consumer market and you know the shrinking nature of beer in comparison to spirits. Every few months, a DC one goes out of business lately. Yeah, more to my point, I think we're seeing a lot of that here in North Carolina as well. Um, you know, much of independent craft is now owned by big players. Yeah, I think that that in time will tell whether big beer, as we'll call it, um, Miller Coors buying through 10th and Blake. That's their version of AB InBev's high end. They went on a spree of brewery acquisitions in 2013, 14, 15, 16. Um, but what we just saw not very long ago, and I think something I even talked a tiny bit about on stream was, um, what was it? I'm forgetting the name. The company that acquired Sweetwater out of Canada, the cannabis company. Um, Somebody in the chat help me out here. Anyway, AB InBev just sold a host of brands and breweries to that entity for what $85 million in cash, right? Um, Basically resulting in a major loss on the company books, but that says a lot about the medium to long term projections of craft. There's a whole brewery slash eateries thing in Mendocino County, small brews. Yeah, I actually, and just to, I think my law partner and I actually acquired a building in a small town here locally, and we bought it from a former client of ours in the beer industry, and we had helped him acquire the building and permit the place, um, fund a lot of the upfits and stuff like that, and we actually took over that operation as an ongoing concern when we bought the building. And just to give some level of, like, transparency to you all, that I'm not just speaking only in hypotheticals or theoretically, we liquidated the entire manufacturing side of that operation and began private labeling the production of our in-house products and pivoted to a taproom model that did not require us to actually manufacture in-house, right? Um, and I think you'll start to see a lot of that. If you shop at Costco, the Kirkland's brand of wine, that's a private label product that is Costco's house brand, right? That is, the industry itself is overbuilt. And when I say overbuilt, I mean physical stainless steel um, production equipment. Many people wanted the badge of buying new, right? So there's a lot of Chinese steel laying around, all over the United States. But I referenced first time business owners earlier. So, um, you know, production equipment is cheap right now. So consultation comes with a drink. Yeah, I mean, if we're in the area, but you know how it goes now. Bell's was purchased by Lion. They were one of the oldest independent. Yeah, but you still got what, Yingling, which I think is shining star, really. I love that they're in the millions of barrels per year production threshold and still family owned. I think we should cherish that. Let's see. Yeah. So anyway, hopefully we kind of salvaged a little bit of this stream. Do apologize, everybody. I should have pushed harder to give us another day here. So I'll own that one. Norm will be back. He'll be all right, but appreciate the well wishes from you all. Let me jump over here to Rumble. Thinking Man says, overall, has craft beer peaked or is it growing steadily? Seems craft beer is like biotech. It started small, hoping to be bought out for the big money. Um, how do I answer that? Has craft beer peaked was the first question. I don't know. Um, I think the apex of what was defined as sort of Instagram culture, I think that certainly has come and gone, right? I think that whatever stardust existed around the likes of Treehouse and Trillium and Weldworks and many of those. Yeah, I think that that's all gone, but I don't know that the winner. The point is that this is a second or third generation or a, saga in the chapter of um, domestic beer production, right? So we can attach whatever label. It used to be sort of like, what was it? It was before it was craft, it was something else. I can't even remember now. Not small batch, but like micro breweries and stuff like that. The idea, the dream is to actually grow and scale, right? And there was a period where the likes of, Ballast Point was bought for $1 billion at a the hallmark of all craft beer valuation mania. Yeah, Julian, sure, for sure. Was sort of, I think, encapsulated with the purchase and sale of Ballast Point for like literally $1 billion, and then the subsequent sell-off of that brand for less than 100 million just 3 or 4 years later. So to that end thinking, man, I think that, yeah, your question is, has craft beer peaked? Certainly from an awareness and from a, sort of a new thing a la craft for sure. Growing, no. I think, we've now entered an era where there is negative growth, but that is really from a perspective of the rate of new openings. I mean, at one time, there were new breweries opening a handful every week and month, and this sustained for several years. I blame the Brewers Association a lot for some of the current failures we're seeing in the market, and that's just because they, for a long time, were pushing this model of, on premise exclusively, sort of like taproom focused operations that were all in person. And I've seen many, 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 many producers struggle when the in-person stuff was shut down state to state during COVID. And the only players that could actually survive and grow were those that had wholesale accounts and off-premise sales to lean into. Others were struggling just to get their products out the door. G. Michael 8 says Foothills is the best beer. I like Foothills, and they're one of the oldest here in North Carolina. So certainly trailblazed for a lot of local players, especially here in the Triad. Let's see. Legal psychedelics. Julian, is there an actual link to that? Let's see. The long haul is where it's at. Stress and an aging body. No bueno. If Norm is unwell tomorrow, will you still be on? Janet, I could be convinced. But I'm not the star here. I just I'm only here to throw alley-oops to Norm. What is up with the brew limits? G. Michael, I assume you are talking about production limits for self-distribution. Can you confirm before I go off on a tangent? Mari says Pliny the Younger is my current fave. Like what do you have against Pliny the Elder? I worked at ROLM and would have lunch with Peter Strasberg, aka Pete's Wicked Ale. Lots of people got huge retirement buyouts in Silicon Valley in the 80s and started businesses. Yeah, I mean there are other, look, I've got clients that have, pedigree that stretches into the Miller Coors and the AB InBev, stuff like that. So the fingerprints of big beer are all over craft, even if it's not from a perspective of, a brand was acquired. I think that for as many people as there are out there that are first-time business owners in the space, those are more sort of like hand-to-mouth opportunists. But there are plenty, burning sensations, your point is well taken. There are plenty of, and I'm sure some of those people were subject to non-competes as well. I think YouTube removes links, probably. G. Michael says yes. Let's see. Okay, so G. Michael asked this question, what's up with the brew limits? So I'll speak only from North Carolina on this one, but the reference that is made with that question is something like this. I talked earlier about the 3-tier system, which in principle mandates an independent wholesale distribution tier that exists between a supplier and the retail market, aka someone that manufactures the beer has to get their product into the retail market by way of an independent wholesaler, meaning that they don't have a financial interest in the wholesaler, right? Small breweries, however, arguably cannot impact the market in any meaningful way in terms of, influencing the market prices and manipulating stuff that would become sort of an antitrust issue. And so in North Carolina, there's a history. The Red Oak sign always talks about brew limits. Yeah. Red Oak was one of the OGs in, certain movements in North Carolina, like such as raise the cap. In other words, raising the limitations on alcohol by volume, or ABV. At one time, here in North Carolina, the limitation for beer is 14%. But for a long time, it was less than 8, I think. Norm isn't focused. This is sad. You're my hero. You're kind of late, so he drops out there. Anyway, so brew limits. North Carolina decided to become one of the most progressive regulatory regimes in the Southeast and perhaps the country. I'm a big fan of the system that North Carolina implemented. I'm usually very critical of, government and state action on this stream, but by and large, I think that the cognitive dissonance that I have to kind of acknowledge is that I'm often sort of a stand for more principled public policy positions with respect to controlled substances, particularly beer. And so I think that there's great justification for the 3-tier system because it's a very easy slide from manipulating downward price pressure on alcohol and encouraging other illicit acts such as prostitution, drug dealing, all sorts of other behavior that happens when people's inhibitions are gone, et cetera. Alcohol is a very sensitive thing. So while I understand its role in society and culture, I think that logical and reasonable limitations on the way that businesses can encourage certain other behavior and drive out competition by forcing price down on products. And that was my reference to earlier when I was talking about, getting rid of the manufacturing system and whatnot, is that, volume is key, right, in this game, especially in beer. But the brew limitations that are referenced by G. Michael is essentially this. North Carolina adopts the 3-tier system. However, in its current form, it allows for what are called small breweries, and that's a term of art. A small brewery to self-distribute, to do a couple of things. One is to self-distribute its product into the market. So in other words, North Carolina's laws allow for smaller producers to vertically integrate. Not only can they self-distribute their products to other licensed retailers in the state, but a small brewery, and this is what the consumer experiences as a tap room, a small brewery can open a tap room and have people come in and buy products directly from them. And not only that, in North Carolina, a brewery can open up to, I think, if I'm correct here, up to 5 or 6 taproom locations, notwithstanding having additional production facilities in a couple of those. But it gives great runway for early growth, right? And meeting your consumer where they are, controlling your product's path to market, being able to make sure that your product is well represented, that you can educate your consumers, and that you're developing your local market in the way and the manner that you see fit. However, there is a threshold at which a brewery by law must run its products through a wholesaler in order to access the retail market. And in North Carolina right now, it's weird. The law changed a couple of years ago to make the small brewery exception apply to producers manufacturing 100,000 barrels, less than 100,000 barrels per year, which for the uninitiated is a crazy amount of beer to be considered small. The average craft brewery is doing in the realm of hundreds of barrels per year. And I'm not understating that. So for a small brewery to have runway to the tune of 100,000 barrels is insane. And now I want to put an asterisk on that because the first 50,000 of that produced, you can self-distribute. Then the next 50 has to go through a wholesaler. And then if you go over the 100,000 in 1 year, then you have to turn all of your rights over to an independent wholesaler. Um, for all practical purposes, it's a meaningless distinction. It basically, the law functions to basically allow small breweries to grow to the point where they can decide when it is better to hand their products over to essentially a logistics operation. That is what a wholesaler is, to get their products into the market, right? Because that's a whole separate business. It's actually, you know, contrary to popular belief, it's not desirable to also run a wholesale distribution operation or a logistics operation in addition to a manufacturing operation, right? That's why in the private sector, these things naturally develop as independent entities because businesses can find efficiencies by, delegating jobs to other vendors, right? So interesting stuff. Thank you for that question, G. Michael. Take home growlers. Yeah, I like growlers, the canned version of growlers. I say we brew our own beers, brew your own beer. Yeah, I mean, just to take your name, been there, done that. Anyway, okay, we'll be back tomorrow morning. Hopefully, I'll talk with Norm. But thank you guys for your concern. And again, I do apologize for, and I should have, like I said, I own this one. I should have pushed a little harder. So I'll go take care of Norm, and I will update everybody on X. Mark and VT, Mike, good solo today. Best wishes to Norm. Yeah, thank you. And thank you, everybody. I'm just going to go ahead and end it now. So I'll see you tomorrow.